Sure. Daniel Graham and Adam Carruthers, during the late evening of the 27th of September 2023, you set off from your homes in the Carlisle area, travelling together in Mr. Graham's Range Rover to the car park below Sycamore Gap. You went with the intention of felling the sycamore tree which had grown in the dip in Hadrian's Wall near Crag Lough in Northumberland for well over 100 years. As experienced tree surgeons, you took with you the tools which you needed for that task: a chainsaw with a long blade of sufficient size for the girth of the trunk, and a can of spray paint to mark the outline of the wedge in the trunk which you intended to cut. It was a dark night and the weather was stormy. During your journey of around 40 or so minutes, you travelled through Brampton and along the military road towards the Twice Brewed Inn, and then turned left up to the Steel Rig car park. You arrived there shortly before midnight. From the car park, you both walked for about 15 or 20 minutes to the tree, and you set about your task. Mr. Carruthers, you marked the trunk with spray paint to assist in cutting out a wedge from the trunk to create a hinge. You felled the tree, a process which lasted no more than 2.5 to 3 minutes from start to finish. Mr. Graham, you had taken up a viewing point a short distance from the tree and recorded the felling of the tree on your mobile phone. The jury was shown the enhanced footage from that phone created shortly after midnight. It showed the outline of Adam Carruthers using the chainsaw, pausing to lift the wedge out of the trunk, the further cutting, and then the tree crashing down over Hadrian's Wall. Having done what you set out to do, you both returned home, retracing your journey down from the car park at Steel Rig towards the military road at 58 minutes past midnight. You took with you the wedge of trunk which had been cut from the tree as a trophy. During the journey home at 1:30, Mr. Carruthers, your partner, sent you a video of your newborn baby being bottle fed. You responded with the message, "I've got a better video than that." Only a few minutes later, at 39 minutes past 1, Daniel Graham forwarded to Mr. Carruthers' phone, no doubt at his request, the video of the tree being felled. In its unenhanced state, of course, this video showed nothing. When you returned to Daniel Graham's yard at around 2 a.m, you took images of the boot of the Range Rover containing the chainsaw and the wedge of trunk which you'd taken from the tree. The timing and location of these images have been confirmed by expert analysis of Mr. Graham's phone, and the images themselves have been examined by experts who confirm that the objects were in the boot of Mr. Graham's Range Rover and that the wedge was taken from the sycamore tree. Neither the chainsaw nor the wedge of trunk have been recovered. Early the following morning, the damage to the tree and to the wall was discovered. P.C. Barini was the first officer on scene. He recognised immediately that the tree had been deliberately felled. He noticed the spray paint on the stump and suspected that a wedge had been cut out of the trunk. He looked for the wedge but could not find it. News of what you had done spread quickly. Shortly after 9:35 a.m, you, Adam Carruthers, sent Daniel Graham a photograph of the felled tree on WhatsApp. Mr. Graham, you responded, "Here we go." Later that morning, as you followed the story on social media and on mainstream news, you both revelled in your notoriety. You, Mr. Carruthers, commented, "Someone there is tagged like ITV News, BBC News, Sky News like news, news, news. I think it's going to go wild." Later you said, "It's gone viral, it's worldwide. It will be on ITV News tonight." During the day, you exchanged images of the tree and screenshots of conversations on social media. At one point during the morning, a man made the comment that the person who felled the tree must have been weak. In mock indignation, you, Mr. Graham, responded with a voice note saying, "Weak?" A moment or so later, you, Mr. Carruthers, sent a voice note to Graham in which that you would like to see him launch an operation like we did last night. You continued to follow the news coverage over the next days, exchanging messages and sharing screenshots. You followed the coverage of stories of the arrest of a teenager and later of an older man who was arrested in connection with this offence. You were both then arrested on the 31st of October 2023. Daniel, Graham and Adam Carruthers, on the 9th of May of 2025, the jury found you guilty of 2 counts of criminal damage. The first count concerns your felling of the sycamore tree. The second, the damage to Hadrian's wall caused by the sycamore tree falling onto it. I now sentence you for these offences. I have set out the facts of which I'm sure. I've taken into account not only the evidence which I read and heard during the course of your trial, but also the accounts that you have each given more recently to the probation officers who interviewed you for the purposes of the pre-sentence reports. At the trial in May, neither of you accepted any involvement in the tree felling. In your recent interviews with the probation officers, although seeking to minimise your culpability, you have, however, both admitted being present and involved. And it's on this basis that I can now be sure that you, Adam Carruthers, were the person who felled the tree, whilst you, Daniel Graham, assisted and encouraged him by driving there and back, and not least, by filming the crime on your phone. The Sentencing Council has published offence-specific guidelines for criminal damage other than by fire value exceeding £5,000. These guidelines have been enforced since the 1st of October 2019. The Sentencing Council made clear in its response to the consultation before that guideline was introduced that its aim was to ensure that all sentences are proportionate to the offence committed and in relation to other offences. Under Section 59 of the Sentencing Act 2020, the Court is required to follow sentencing guidelines relevant to the offender's case, unless satisfied that it would be contrary to the interests of justice to do so. I must impose a sentence which is within the offence range specified in the relevant guideline, unless it would be contrary to the interests of justice to do so. The offence range in the relevant guideline is discharge to 4 years imprisonment. If I determine that a term of imprisonment is necessary, then the term of that imprisonment must be the shortest term commensurate with the seriousness of the offence. Where a case falls within the guidelines will inevitably be fact-specific. Comparison with previously reported cases is unhelpful. It's for me to decide where the appropriate level of sentence falls for this offence committed by you both, having regard to the culpability and harm factors set out in the guideline, together with any adjustment for aggravating and mitigating factors. The guidelines require me to identify the offence category by reference to your culpability or blameworthiness and by reference to the harm caused. And I make the following findings and observations, therefore, concerning your culpability. First, I am sure that the offence in count 1 involved a high degree of planning and preparation. I can't be sure when you made the plan, and I accept it may only have been made earlier that evening, but the venture required thought and preparation. You had to work out how you were going to get to the tree and had to ensure that you had the necessary equipment with you, including a long blade of the correct dimensions for the trunk and spray paint. It took effort. The venture involved a round trip of some hours, travelling at night during Storm Agnes. You had to carry the equipment from the Steel Rig car park up to the tree, fell the tree in the dark and during the storm. You then had to carry the equipment and the wedge of wood taken from the trunk back down. You, Mr. Graham, remarked the next day, in response to a comment on social media, that the author of the comment did not know how heavy. Second, it follows that I'm satisfied that you intended to destroy the tree. Whether when you set off you intended to cause damage to the wall is less clear. I don't believe that you'd focused on the wall, and to that extent the wall was collateral damage. However, as experienced tree surgeons, you would have known that the angle of the wedge that you cut and the direction of the wind that night meant that the tree would inevitably fall over the wall. It was fortunate that more damage was not caused, simply because the wall was protected by the canopy of the tree. Third, whilst your motivation for felling the tree is not clear in every respect, I am satisfied that you are both equally culpable. Mr. Carruthers, you told the probation officer that you had no idea why you had carried out the crime and could offer no explanation for your actions. You blamed drink, saying you'd drunk a bottle of whiskey after a tough day and everything was a blur. Mr. Graham, in your interview with the probation officer, just as at trial, your main focus seemed to be to heap as much blame as possible on your co-defendant. You now accept that you were present, but blame him for what happened that night. You provided me with a witness statement from a Mr. Paul Fox. The statement takes the form of a character testimonial. However, that statement repeats the contention that you were not the instigator of the offence and that your good nature had been exploited. Referring to Mr. Carruthers, you told the probation officer that it was his dream and that it was his show which you just went along with. You said that you went with him that night not thinking that he would go through with the plan and that you were shocked when he did. You described him to the probation officer as a fantasist who had on other occasions damaged property to mark significant personal events or milestones. You say the wedge was taken by Mr. Carruthers as his trophy. Although there may be grains of truth in what you have each said, I do not accept that your explanations to the probation officers are wholly honest, or indeed the whole story. Mr. Carruthers, your account that you had had so much to drink that you had no memory of what you did that night is not plausible. The tree felling demonstrated skill. It required deliberate and coordinated actions by you. As Mr. Graham commented the next day, having seen a photograph of the stump, you didn't get a bad angle on the stump and the job seemed professional. This was not the work of someone whose actions were significantly impaired through drink. Nor, Mr. Graham, do I accept that you just went along with your co-defendant. You filmed the whole event. You took photos of the stump and chainsaw in the boot of the Range Rover. The next day you appeared to revel in the coverage of your actions in the media. This is not the behaviour of someone who was shocked and horrified by something that had happened. I'm confident that a major factor in your offending that night was sheer bravado. Felling the tree in the middle of the night and in the middle of the storm gave you some sort of thrill, as did the media coverage of your crimes over the following days. You revelled in the coverage, taking evident pride in what you had done, knowing that you were responsible for the crime which so many people were talking about. Whether bravado and thrill-seeking provide the complete explanation for what you did, I do not know. However, as I say, I'm quite sure that you are both equally culpable for the destruction of the tree and for the damage to the wall. As to the harm which you caused, I've received expert reports from the prosecution and from the defendants attempting to place a financial value on the sycamore tree. But no one submits to me today that the precise financial value matters. It's common ground that the tree is valued at more than £5,000, which is the relevant threshold for the purpose of identifying the sentencing range for this offence. I've read the statement made by Mr. Andrew Pode of the National Trust, which owned the tree. I note the cost to the National Trust, a charity, associated with the broad-ranging work which the various teams have had to undertake following the tree felling. The cost to the charity in removing the tree and the subsequent clear of the site alone currently stands at over £30,000, with a further £20,000 committed to be spent in 2025. But when considering the harm caused by your actions, my focus must be upon the social impact of the offence. The contents of Mr. Pode's statement and the examples of heartfelt messages from members of the public he has provided reflect my own impression from media accounts of the public's reaction, which was one of widespread shock and bewilderment. For those who live in Northumberland or who love this county, the tree had become a landmark, a symbol of the beauty of its untamed landscape, featuring prominently in local art and local tourism. For others, the tree had become a place of special personal significance, where marriages were proposed and personal tributes to loved ones were left. It was, as Mr. Poe observes, a place of peace and tranquillity to which people returned year after year. But the public reaction has extended far beyond those who had visited the tree or for whom it had a personal resonance. Mr. Poe describes the outpouring of emotion as unprecedented in the experience of the National Trust. He describes the sense of loss and confusion across the world when the news broke that a thing of natural beauty had been destroyed in a mindless act of vandalism. Following the guidelines, the first step that I must take is to identify the offence category. It is common ground between your barristers and the Crown that the offence in Count 1 falls into the highest categories for both culpability and harm. It falls into the highest culpability category for two reasons. First, because the decision to fell the tree involved a high degree of planning and premeditation. And second, because you intended to destroy the tree and thus intended to cause very serious damage to property. It falls into the highest harm category because of the social impact of the offence, causing serious distress to many people. This yields a sentence range of 6 months to 4 years custody, with a starting point of 1.5 years custody. On Count 2, the prosecution submits that the criminal damage to Hadrian's wall falls into Category B, medium culpability, on the basis that you were reckless as to whether your actions would cause very serious damage to the wall. I accept this categorisation. I also accept that the damage to the wall, unlike the damage to the tree, is capable of financial valuation, and that the costs associated with repairing the wall, including the staff cost to the National Trust, amount to just under £7,500. For an offence of medium culpability and harm falling into Category 2, the sentence range extends from a medium-level community order to 9 months custody, with a starting point of a high-level community order. Count 1. Under the guidelines, the starting point for an offence of criminal damage falling into the highest bracket of culpability and harm is a sentence of 1 year and 6 months custody. However, I must then consider adjusting that starting point upwards or downwards, as may be necessary to reflect the particular features relevant to culpability and or harm in the particular case. I have no doubt that the starting point of 1 year and 6 months custody must be adjusted upwards in your cases for a number of reasons. First, because there are two factors, each of which bring your offending within the highest culpability bracket. More significant, however, is the extraordinary social impact which I've described of your offending, and I've no doubt that these factors justify an increase in the starting point to the very top of the guideline bracket for this offence, before consideration of aggravating and mitigating factors. The guidelines then require me to take into account any aggravating factors. One aggravating factor specified in the guideline is the fact that damage has been caused to a heritage and or cultural asset. However, I accept that I must be cautious not to double count aggravating factors. I've already substantially uplifted the starting point to reflect the very widespread distress caused by the felling of the tree. This reaction is in large part linked to the tree's status as part of the landscape and part of our natural heritage. It would be wrong to uplift the sentence still further for what is essentially the same reason. Mr. Graham, you have 4 previous convictions, 2 for battery and 2 for public order offences. Your previous offending was linked to relationship difficulties, and in each case you received a financial penalty. I do not regard your previous convictions as relevant to the sentence which I must pass today, and I do not regard them as aggravating factors. However, there is a further aggravating factor not specified in the guideline which justifies an increase in the sentence. You appeared to savour the fact that others, including a teenage boy, were investigated for the offences which you had committed. This additional aggravating factor leads me to the conclusion that before mitigation is considered, the sentence falls over the top of the guideline bracket of 4 years imprisonment. I'm then required under the guidelines to take into account mitigating circumstances. I've read detailed pre-sentence reports, and in your case, Mr. Graham, a mental health assessment report prepared by the Crown Court Mental Health Liaison Team and a further expert report prepared by a consultant forensic psychiatrist, Dr. Steve Ramplin. Daniel Graham, you are now 39 years old. You've worked for most of your adult life, and I've read testimonial statements which, amongst other things, say that you are hard-working, polite, and generally helpful. In the recent past, you've been self-employed, living in a caravan sited on land which you own. The author of the pre-sentence report focuses upon your relationships and linked mental health problems. You had a turbulent childhood, suffering physical and mental abuse. You had a close and supportive relationship with your father, however, and his suicide in 2021 affected you profoundly. Dr. Ramplin has explained that you've experienced mental health problems throughout your adult life, and those problems have included depressive episodes of marked severity. Since your father's death, you've attended Mr. Carruthers, you're now aged 32. The pre-sentence report records that you have 2 children with your long-standing partner. One of those children has special needs. You've worked hard throughout your adult life, and you are, or were, financially secure, having been employed at Cumbria Turf for many years. The author of the report describes you as demonstrating emerging remorse, although still struggling to accept responsibility for your actions or to recognise the impact of your actions on others. You have no previous convictions. As I've remarked, I must take into account in your favour any mitigating factors. I've considered Mr. Graham's background mental health problems carefully. However, it appears from the report of Dr. Ramplin that you, Mr. Graham, do not regard those problems to be relevant to your offending, nor do I. Your offending that night was not in any way caused by or linked to your mental health. Further, according to the report from Dr. Ramplin, your depressive illness is currently in remission. You reported to him suffering no significant depressive symptoms, no suicidal ideation. You demonstrated a reasonable function both in interview and in prison, and you are coping well in prison. Whilst acknowledging that your mental health history is informative background, there is nothing in the material available to me today to suggest that a custodial sentence will weigh more heavily on you by reason of your diagnosis or your mental health history. I've also read and understand the testimonial evidence served on your behalf and take into account that your caravan has been damaged and that you've received hate mail as a consequence of your conviction for these offences, but I'm afraid I do not regard these as mitigation either. I've taken into account Mr. Carruthers' personal circumstances. I accept that Mr. Carruthers is an active caregiver to his children, including one with special needs. But I'm told that that child is coping well in mainstream school and that your partner is able to care for the children. In short, whilst acknowledging again that your personal background is informative, it does not, in my judgment, afford a basis for reducing your sentence. I accept that in the case of Mr. Carruthers, there is some modest mitigation in the form of an absence of previous conviction which justifies a discount. Mr. Graham, you have previous convictions, but as I've said, they are for very different offences to those which you face today. I've considered carefully whether I should afford only Mr. Carruthers a degree of credit to reflect his character. However, this is a case in which I have an overwhelming sense that both defendants should receive the same final sentence. Mr. Carruthers, you will receive the benefit of the discount for having no previous convictions. Mr. Graham, you will receive the same discount, although you do in fact have convictions, but they are not, for my purposes today, relevant convictions. I'm required to pass a sentence which falls within the offence range set out in the guideline unless I'm satisfied that it would be contrary to the interests of justice to do so. Considering count 1 on its own, I'm satisfied that the guideline offence range is sufficient, taking into account aggravating and then mitigating factors. And the Crown accepts that the offence in count 1 is properly dealt with as being in the most serious category covered by the guidelines without the need to go outside those guidelines. As I've already said, the guideline range for a Category 1A offence extends to 4 years imprisonment. Count 2. As I've remarked, the starting point in the guidelines for count 2 is a high-level community order. Again, I must consider whether there are factors in your cases which justify an adjustment of that starting point upwards or downwards before consideration of aggravating and mitigating factors. There are no such factors, but the offence in count 2 is, in my judgment, significantly aggravated by the fact that you caused damage to a heritage asset, Hadrian's Wall. The actual damage to the wall was relatively modest, comprising only of spoiling and fracturing of some of the stones, but it is a World Heritage Site and a protected monument. As Mr. Macfarlane of Historic England has stated, the wall is a major archaeological site and an important tourist draw to the region, and I'm satisfied that a short custodial sentence is appropriate for count 2. I've had regard to the sentencing council guideline on totality. Counts 1 and 2 arise from the same facts. In these circumstances, it is appropriate that I impose a sentence in count 1 which reflects your overall criminality and impose on count 2 a sentence which will be served concurrently. When considering the sentence to be imposed on count 1 in these circumstances, it is not a simple arithmetical exercise of adding one sentence to the other. The sentence which I pass must be just and proportionate. The sentence on count 1 will therefore incorporate a part of the sentence on count 2, but not the whole of it. I made a reduction to the sentence to be imposed on count 1 to reflect, in Mr. Carruthers' case, the absence of convictions, and in Mr. Graham's case, the absence of relevant convictions. The increase which I make to the sentence in count 1 to reflect part of the sentence in count 2 has the effect of cancelling out that reduction. Finally, I am satisfied that the term of imprisonment which I pass is the shortest term commensurate with the seriousness of your offending. I make deprivation orders in respect of Mr. Graham's Range Rover and Mr. Graham's mobile phone, both of which were used for the purpose of committing or facilitating the commission of offences. The victim's surcharge applies. Stand up, please. Mr. Daniel Graham, Mr. Adam Carruthers, I pass the same sentence in respect of you. The sentence is, on count 1, 4 years and 3 months imprisonment. On count 2, 6 months imprisonment, but to be served concurrently with the sentence on count 1. Daniel Graham, you've been in prison since the 21st of December 2024. Adam Carruthers, you've been in prison since the 9th of May of 2025. The days that you've served will count towards your sentence. I've imposed a sentence of 4 years and 3 months imprisonment. You will be released no later than 40% of the way through the sentence, and the remainder of the sentence will be served on licence in the community. You must comply with all the conditions of your licence, failing which you will be at risk of recall to prison to serve the remainder of the term in custody. Thank you. I may go down.
court when they got the sentence. Yeah, okay. CPS coming out?
Yes, in a few minutes.
No, the shooting the step.
Any minute. Yeah, I'm 5 miles off.
And how do you think we'll be drying it?
Can you JP them out? Yeah. Yeah, I'll pick them. Brilliant. Thanks very much. Right. Yeah. Oh, okay, no problem. Thank you. Change them around so they rain hard on your lens, or
You don't want the water down anywhere else?
well, they can just put them here. Get them watered down. It's all right. If you want to let it rain on your lens,
I'm not bothered.
it's not bothered.
It's not on my lens.
Which one? I don't know if I've got them on that one. Yeah, I think I was at the BBC on when's that going on? Is it? Yeah, on that one. Time is 4 to 11, isn't it? So 7:30 on the iPhone or what?
That's right, that's what you're saying.
Yeah. Is it not going out on
I'm into Villa. See, Villa.
Like normally does. You guys read them?
Well wishes.
She's going for a wee.
Then she needs to get back to her travel lodge. I think she's going to come out. She's got your umbrella. She doesn't know it's your umbrella. My colleague thought it was my umbrella and was told her she could borrow it and take it over to the travel lodge and then we collect it. So if you could live without it and maybe get it off her at the travel lodge. But she's coming out again in a minute. I'm just going to go over and do my live stuff. But when she comes out again, one of you can go grab her. Okay.
Yours is dry there.
Yes, well dry. Hi. Sorry.
It's all right. Hello. Enough fun.
If I'm down here like that, be alright with it.
Oh, yes. Where he goes? Someone else on the press association. It's an agency who works for a lot of different things. So I've got your name before. Yeah. Of course, yeah. Just tell me again, why did you come up today? Because I wanted to be at the sentencing and I wanted to see justice done, which I'm disappointed because we haven't. I don't think that was justice. I don't think it's long enough. No. It should have been 7 years. But why? What they come here for? To cut a tree down? They live in Cumbria. There's plenty of trees in Cumbria that they can cut bloody down. Yeah. Why come and do all this? I know I'll probably get bloody shot on and stab or something for saying it, but I don't care. I'm 78, he's 84, and I couldn't give a fuck what I say.
And you come up on the train?
Yeah, especially for this. I'm recovering from a major operation, and I was getting well in it. Yeah. Wolverhampton, we've got the train on Sunday. I'm stopping for a few days, but we came here especially for the safety.
What made you think it's so important to
Because it's our heritage. It's our heritage. We are Geordies, and as I say, Hadrian didn't chop it down. Hadrian built and go around the Sycamore Gap. So if Hadrian can build around it, why should a couple of idiots from Cumbria come and chop down our assets? You know? Rubbish. Should have been 7 to 9 years. Should have been. What can you do there? Justice in this country is gone. And there's not 40% of the reformers. No, I don't know.
Yeah, let's try and think.
Yeah, we're doing the first. Take the job. Anyway, can I go now?
No, it's really one here.
Yeah.
You ready? The felling of the iconic tree at the Sycamore Gap site in September 2023 was a deliberate act on the part of Daniel Graham and Adam Carruthers. Since the felling of the tree, both men have tried to evade the consequences of their criminal actions, cynically lying about the part they each played and blaming each other for the mindless destruction of this historic landmark. Over the course of their trial, the Crown Prosecution Service meticulously picked apart their fabricated accounts of these events, demonstrating beyond doubt each man's direct involvement in securing custodial sentences against them both. No financial figure alone could ever convey the true scale of the damage caused by the pair's actions. The universal reaction of disapproval and anger following the destruction of the site speaks volumes of the emotive impact on the public. We only hope that those affected by these events can take some comfort in seeing those responsible jailed today. Thank you.
Can you confirm your name and title, please?
Yes, I'm Chris Atkinson. I'm a Senior District Crown Prosecutor with CPS North East.
Right, thank you.
Thank you.
Huge favour. Know that interview that you did with that woman? Can you send that to me? Yeah, of course. Thanks so much, because I was set up and I couldn't. Yeah. Thank you so much. It's just on WhatsApp. One sec, let me. Yeah, that's fine. Yeah. Thank you.
It's not about